Everyday injustice. Too many wrongful convictions. Corruption has infected the criminal justice system, leaving too many people helpless, fighting for their lives. Instead of receiving justice, people suffer. Is that why they say justice is blind?
Hello, and welcome to the Everyday Injustice Podcast. I'm your host, David Greenwald. For the past 10 years, we've operated Vanguard Court Watches in California, including San Francisco, Sacramento, and Yolo counties. Our goal? Expose everyday court injustices, and now, more broadly, shine a spotlight on injustices in the entire criminal justice system, in the form of wrongful convictions, police and prosecutorial misconduct, and mass incarceration. This podcast hopes to take it a step further and highlight criminal justice reform on a national level.
Everyday injustice.
Today on Everyday Injustice, we have Marc Bookman. He is an author and the co-founder of the Atlantic Center for Capital Representation. Welcome to our show.
Thanks for having me.
So we're going to talk a bit about his book, A Descending Spiral, Exposing the Death Penalty in 12 Essays. But I'm really curious how you got into the death penalty work in the first place.
So, I get asked this question a lot, mainly because I would seem to have very little personal ambition. I was a public defender for 28 years, and I've been running this nonprofit for the last 10. And as a public defender, I never really wanted to be anything else. But I also wanted to do the work kind of at the top of the pyramid. So the death penalty is obviously that work. It involves the most serious cases and the most serious decisions. It's also fascinating for one other reason, which is that the question of whether or not we should execute someone is really the only moral question in the law. All other questions are, was the light green or was it red? Were the elements of the crime made out beyond a reasonable doubt, or were they not made out beyond a reasonable doubt? The only moral question that we ever ask in any case, civil or criminal, I think, is this one. So it's certainly something that I think has always attracted me, that moral question. So I guess it's a combination of the most serious work and the most fascinating issue.
And, interesting that you brought up the moral issue because, I think there are kind of two issues really with the death penalty. One is the moral issue. And, personally, I'm morally opposed to the death penalty, but I also think there's a functional issue as well, which in a lot of ways is much more interesting because we can, the average person is going to agree or disagree whether or not there's a moral problem with the death penalty. But there's a big functional problem with the death penalty.
David, I could not agree with you more. If someone wants to tell me that they don't have a moral problem with the execution of someone who's committed a horrible crime, okay, I'm going to disagree with them. But I'm honest enough to recognize that there's a significant population that thinks that way. But the practical issues, I think. The practical issues are overwhelming, and to some extent, I always try to encourage people not to separate the two, because if you really understand the practical problems, that has to affect the moral decision, and so yes, the practical issues are compelling, to say the least.
So, in terms of the practical issues, as you put it, what do you see as the biggest problems, and which ones do you kind of highlight in your book?
So, when I started out writing these essays, I really tried my best to focus on on individual issues. I tried not to overlap. Bad lawyers, prosecutorial misconduct, improper judicial behavior, whatever the issue was, and I had quite a number of them. But the one issue that I think runs through almost every essay and cannot be separated out is the racist aspect of the death penalty. It permeates really almost every case, and that's the one issue that I don't know how you overcome it, in our lifetime anyway. So yes, that's some of these issues can be solved with money. You want to get better lawyering, then provide lawyers with proper resources and proper training and proper consultation. You're going to have competent lawyers handling these cases. You want to affect prosecutorial misconduct, open files and change the culture of prosecution from a win-loss to a justice perspective. But how do you remove racism from the equation? I don't know if anybody's figured that one out.
Yeah, and I think that's a big problem throughout the system. Obviously, I mean, one of the arguments I was making this week with respect to the police issues is that what the Tyree murder really shows is that unless you can address systemic racism in the system, there is no protection that you're ever going to get. And the death penalty is kind of the same way.
Yeah, it's a cultural sea change is necessary, and it comes slowly and not steadily. I mean, in Philadelphia, we elected a true reform prosecutor, Larry Krasner, and he really is a reformer. Other people have kind of used the label to get elected. He's a true reformer, and being a true reformer, I'm not a huge Star Wars fan, but it's like, I'm always thinking The Empire Strikes Back, because they didn't, the empire, the court administration, the structure of criminal justice in Philadelphia over 40 or 50 years has not taken kindly to Krasner's reforms. These things are going to be slow. The cultural changes are going to take time. I mean, the Pennsylvania legislature impeached Krasner foolishly because they just didn't like his policies. But so this is a long, slow slog. And you're right, the Tyree Mitchell case is just one more example about how, this change is going to be a long time coming.
So where do we see racism come into play in the death penalty?
Well, it's everywhere. I wrote one of the essays is about a racist judge, and frankly, it's not all that shocking that there would be racist judges. What was shocking about this essay for me, or this story for me, was that everybody knew he was a racist. All the court personnel and his family, and this guy was a true white supremacist, and he didn't make any bones about it. He wasn't hiding it. He wasn't kind of secretive about it. Everybody knew, and yet no one said a word until he ran for county commissioner. That's when everybody said, whoa, we can't have a white supremacist as a county commissioner, but it's okay to have him as a judge in death penalty cases. And so that's one way that I thought was interesting. There are, of course, racist prosecutions all the time. I wrote one essay about a very, very mentally ill man, Andre Thomas, he was a black man who had white friends and white female friends. And the prosecutor, in closing, after selecting a jury where 3 of the jurors came out overtly and said they don't believe in interracial marriage. This was an interracial murder. 3 jurors that didn't believe in interracial marriage sat on the jury, and then the prosecutor, without the defense attorneys doing anything about it, and then the prosecutor in his closing said, "How would you feel if this man, Andre Thomas, was dating your daughter or your granddaughter?" and he's talking to an all-white jury. So, racism is everywhere. It's in the judiciary. It's in the prosecution. It's in the defense attorneys sitting on their hands doing nothing. It's in jurors. One of the essays is about a juror who said, I gave that N word, the death penalty because of who he was, basically. So, it's not just one place. It's really omnipresent to a certain extent.
And I'm really interested in the notion that you bring up of, improper judicial behavior, and you talk about racist judges and the example. And, it's kind of interesting because I've spent 15 years watching court cases. And, most of the time the judge is kind of a non-factor. But then, I listened to the audiobook from the Chicago trial from the 1960s, and it was incredible listening to the judge, and it was just eye-opening how bad it could be. Or I remember also reading about the killing of why am I drawing a blank? The Black Panther from Chicago.
Fred Hampton.
Fred Hampton, and the judge in that case just not allowing vital evidence in, and you don't realize how bad a judge can be until you see a really bad judge, I guess is the bottom line. So in your experience, how big a factor is that? So
I'm just gonna interpose a minor objection to the first thing you said, which is, look, the ideal judge, it's just like John Roberts when he was getting brought onto the Supreme Court as the next Chief Justice. He said judges, the ideal judge is just a judge who calls balls and strikes. John Roberts he must have been in courtrooms, but he wasn't paying attention. The judge affects every decision in that courtroom. They're making so many decisions, and to think that they're all dictated by the law is naive. Judges affect trials in every regard, and so the Chicago case, and I think Aaron Sorkin did a phenomenal job. I don't know if you saw that movie. Great. I can't remember what it was called now, the Chicago 7 or whatever he called it. He did a great job there. That's the exception. A judge who is so overt, so out there, so affecting the process. That's not the problem, because that judge at least is making no bones about it. Like you can see it with your own eyes. It's the judges who make bad decisions one after another quietly that are the problem. And so, when I wrote these essays, in my afterword, I wrote something that I thought was important for the readers to know, which is these essays are not outliers. This is typical. I wanted to make sure people understood that I wasn't picking the crazy cases to write about, the overt cases to write about. These are the typical cases. And so judges that make subtly bad decisions over and over and over again, that's typical. Especially when we're electing judges, and we're electing judges who are running on the platform of being pro-death penalty. And we're seeing that more and more these days. One of the essays is about the Chief Justice of Pennsylvania who had signed off on a capital prosecution of a man named Terry Williams, and then went to the Pennsylvania Supreme Court and ruled on the case, and ran on the platform that he had put 45 people on death row as a prosecutor. That was his platform to get on the Supreme Court of Pennsylvania. So this is typical. It's not rare.
And I think that's important. So can you provide some examples of kind of everyday rulings that make a huge difference in terms of death penalty cases.
Sure. I mean, you're selecting. Let's just start with the very beginning. Well, you start with the very beginning, which is pretrial motions. Judges have considerable discretion in cases. I mean, the law allows judges to have that kind of discretion. So, those issues can go unnoticed. I mean, let's go to voir dire, where you're selecting jurors. A judge can take a juror who is clearly pro death penalty, and then lead that juror by saying, I'm asking you if you can set your opinions aside. Can you fairly consider both punishments? And when a judge who's the kind of the power figure in the courtroom asks those kinds of questions and kind of nods his or her head, you're going to get answers from jurors that are going to make them eligible to sit. But the judge he's not looking for honesty in that juror. He's looking to make that juror eligible to sit. That's not the way to pick a fair juror. So, in voir dire, a judge that is going to involve him or herself in the selection process is going to have a huge effect on how that jury turns out. And there's dozens of examples of gory pictures. A judge has the discretion to keep those gory pictures out of the jury's sight or allow them in. And that's a discretionary decision. A judge that consistently allows horrifying pictures to go in front of the jury is a judge that is weighing the case in favor of the state, right? But these are all discretionary decisions. So yeah, a judge plays a huge role in many, many aspects of a capital case.
And going back to the issue of racism, where do we see race come into play here, though?
Well, the first place you see it is in the charging process, right? So, the prosecutor never has to seek the death penalty. There's no case that the prosecutor ever has to seek the death penalty. And many of our most horrific cases have ended in resolution without the death penalty ever being invoked at all. So the first aspect of the possible effect of race is in the charging process, is in whether the prosecutor decides to seek the death penalty in the first place. From there, there are other ways racism plays a role that people don't really think about it. For instance, in Philadelphia, we had court-appointed lawyers working for $1,800 to prepare a capital case. Now, that's a ludicrously low amount of money. And you may not, the racism of that system is not obvious initially. But when you think about it, the system is providing for 80 or 90% of the defendants a ridiculously unresourced, untrained group of lawyers. So if most of the people facing the death penalty are African American in Philadelphia, in any case, and the lawyers representing them are terribly under-resourced and under-trained, that's a racist system, right? That's a system that's not designed for justice. It's designed for expediency and for cost saving. So there's racism just right off the bat in the system that's designed to represent indigent defendants facing possible death.
So, and I know you mentioned this before, but as you pointed out, we can fix that part of the system, right?
We can fix. Yeah, if you're talking about having better defense lawyers, yes, we can absolutely fix that part of the system. In Pennsylvania is the only state that provides no money for indigent defense, none. So it's county by county. It's 67 counties fending for themselves. Well, we can certainly begin to fix that process by bringing in well-resourced, well-trained, competent capital lawyers to handle these cases. Many states have done that. Virginia got rid of the death penalty after they had trained lawyers who basically stopped the death penalty. There wasn't a death sentence in Virginia for 10 years. Then the legislature decided to get rid of it. They were just throwing away money. So that, yes, improving the defense function, that can be done. No question about it.
And that seems like something we should do whether or not we have the death penalty, right?
Of course. The idea that each of these counties is fending for itself is absurd, right? I mean, a county that wants to spend its money on better schools or fixing potholes may decide to save money on the backs of indigent defense. And then we might have good roads and nicer schools, but we certainly don't have a fair criminal justice system in that county.
But I think one of the biggest issues, as I understand it, is the inequity in terms of who gets the death penalty in terms of prosecutions. So, if your victim is white, you're much more likely to get the death penalty than if your victim is black.
Yeah, so that's exactly. I mean, there are two disparities here. One is who's getting charged, and then who's getting it. Both of them are kind of infected with racism. And you're right. The victim, the race of the victim, is really oftentimes the most controlling factor, in the decision making. And this is why, for decades, we did not allow victim impact evidence in the case, because the courts realized that the status of the victim was oftentimes going to control whether a death sentence was returned or not. And that's, of course, a very arbitrary factor. But then the Supreme Court changed, and suddenly victim impact evidence was acceptable. So David, you're exactly right. It's the race and status of the victim that often decides. And of course, that's not how the system is supposed to work.
And you also talk about the impact of judges and judges who overrule the jury in terms of imposing the death penalty. Is there a classic example that you can give of that?
Well, so the first essay I wrote was, and let me just say this, the courts have recently condemned judicial override. There's only a couple of places where it can still happen. And yet there are a lot of people, I think more than 24 on Alabama's death row, who had judicial override. A judge overrode a jury's decision. One of them came very close to execution only a couple months ago in Alabama. So the first essay I wrote about in the book is a capital case where a jury voted 12-0 for one gentleman to get life. His name was Buford White. And Buford was barely involved. Jury said 12-0 for life. The judge overrode the jury, and he was executed in a couple of years. Another man, way more involved in the death penalty, but very, very mentally ill, got a 12-0 vote for death and lived another 30 years before getting executed. So the disparity there is painful. Buford White should never have been executed, and yet was executed only a couple of years after the jury voted unanimously that he should not be executed. What can you say about that other than what the hell is going on? There's no logic to it whatsoever. And yet our United States Supreme Court has never condemned judicial override, even today, 35 years later. And this just lends into the notion that this is an arbitrary
imposition of punishment.
Yeah. So, I called the book a descending spiral for a reason. The more you dig into it, the more kind of horrifying it seems. That what Potter Stewart said was getting a death sentence was like being struck by lightning. That's really the best phrase for it. I mean, you see routinely juries not returning death sentences in very serious cases and for very good reasons. And then you see other juries just coming back with death sentences for low functioning defendants who any way you cut it, their case wouldn't stack up to the more serious cases that get life sentences. The arbitrariness is everywhere, in the charging decision, in the quality of the lawyers, in the jury decision, which of course is impacted by the quality of the lawyers. Potter Stewart was right then, and there's absolutely no reason to think he's not right today. It's still like being struck by lightning.
And then you get kind of this range of problems, and you alluded to some of this. So you have all of these defendants who are kind of low functioning. You see this question of how low is too low for IQ.
Yeah.
Then you have another whole host of cases where there are clear mental health problems, and the system doesn't seem to be able to come up with a reasonable way to handle or account for mental illness that falls short of the legal definition of insanity. And then you have this whole other problem of wrongful convictions and people that are potentially at least innocent, which infects another percentage of cases. And then you get another area where there's all sorts of government misconduct, whether it's police misconduct, prosecutorial misconduct. How do we deal with all of these problems?
David, that's a hell of a question.
I know.
So there's like 5 different things I want to talk about. But one of the things that I wanted to talk about first is the concept of wrongful convictions. It's one of my, so in the book I write, there's a couple of essays about innocent people, but I really want to expand the discussion beyond that, because I think the concept of wrongful convictions is not simply, hey, my client was in Poughkeepsie at the time, right? It's got to be wrong. The concept of wrongful convictions has to be beyond pure innocence. We can't tolerate a system where prosecutors are hiding evidence, even if the client appears to be guilty. We can't tolerate a system where the lawyers are sleeping through trial or drunk or high, even if the client, may be guilty. That's not justice. And so wrongful, it's like kind of my pet thing going around talking about this. The concept of wrongful convictions has to be separated or broadened from the concept of innocent people in prison. That's not controversial. Who could possibly be in favor of innocent people being in prison? I know a couple of people that could be in favor, but most people are not in favor of that. But I would love to spend a little more time talking about wrongful convictions. Let me talk about some of the other issues you brought up. One of the essays is called "How Crazy is Too Crazy to Be Executed." I'm not in love with that title because it sounds glib a little bit, but it brings home an important concept, which is, we have rightfully decided that juveniles can no longer be executed. And we've rightfully decided that intellectually disabled people can no longer be executed. And the reason we've made those decisions is because those two groups of people are less inculpatory. I mean, their thought processes make them less guilty because they are unable to anticipate, future issues and all the consequences of committing crimes. And yet, we don't have the same problem with profoundly mentally ill people who are just as unable to process the consequences, just as unable to negotiate the criminal justice system, just as likely to get caught up in mistakes or police tricks. All the reasons we don't execute the intellectually disabled or juveniles should logically apply to profoundly mentally ill people, and yet we see that as a different category. I can't understand exactly what the thinking is there. So in one of these essays, Andre Thomas, the same man who suffered the racial inequity of jurors opposed to interracial marriage and the prosecutor talking about, do you want this man to date your daughter? He's also profoundly mentally ill. I don't want to horrify the listeners here, but Andre Thomas removed one of his eyes after his arrest, and then blinded himself several years later. He's now a blind man on Texas's death row with an execution date. Texas is actually contemplating executing this profoundly mentally ill man with a long history of mental illness, a long documented history of mental illness, and Texas is still feels it necessary to try to execute him. So, I mean, and you mentioned a couple of other things in your question. I can't even remember now. I guess one of them was prosecutorial misconduct. Some of these essays deal with prosecutors who withhold evidence, then DNA or other evidence comes to light where the defendant is clearly innocent of the charge, and the prosecutors still insist he's guilty. It's like some sort of a mindset where the worst thing you can do is admit you made a mistake. I'm just ranting at this point, David. You can get me back into focus. Feel free.
Yeah, no, you're on a roll. How do we address also the over prosecution on some cases where they're not necessarily innocent, but they've overstated what they've done?
Yeah. So, the problem you're putting your finger on now is what we call the leveraging of the death penalty, which is we'll use the death penalty, we'll use the threat of the death penalty to get people scared to go to trial and to get them to plead guilty. One of the essays in the book, I'm looking it up just to because I can't remember what I called it. The Confessions of Innocent Men was a situation where two low functioning guys got arrested for a serious murder of an eye doctor, and they were both threatened with the death penalty. They both confessed to the crime, and one of them, a man who was clearly intellectually disabled, this is years ago though, a man who was clearly intellectually disabled took a deal for 15 to 30 years and actually testified against his friend. Both of them, 20 years later, were proven to be clearly innocent. So this one guy, both of them were so scared that they confessed. One guy was so scared that he actually took a deal for many years in prison and testified against his friend. But both were completely innocent. That shows you the power of the death penalty and how it can coerce especially when someone is intellectually disabled or low functioning. These two men were clearly innocent. I know because I was representing the guilty man who confessed 20 years later, and there was tons of evidence against him and his partner. So that just shows you how coercive the death penalty can be. And that's the issue with, I'm not exactly getting to overcharging, but that's a problem when prosecutors go out of their way to seek the death penalty with the idea of getting a plea down. There are many other cases we see all the time. Many child killings, and particularly in Pennsylvania, those are horrendous crimes and atmospherically very bad, but they almost never involve a specific intent to kill, which in Pennsylvania is required. So, these cases are awful to talk about, but they rarely involve an intent to kill the baby or to kill the child. It generally happens through recklessness or reckless indifference. But in Pennsylvania, that's not a capital case. And so prosecutors that are seeking death, knowing that there isn't a specific intent to kill, that's what they're doing, what you're talking about. They're overreaching. And, that's what's dangerous about the death penalty. It is very, very coercive.
For sure. And there's also another angle to kind of the mental health crisis that you talk about, where you have children that end up killing their abusers, women that end up killing their abusers, and then also the traumatized people that end up coming out of an abusive situation damaged, and then they end up killing someone. So I mean, and that doesn't count as insanity either, and we don't seem to be able to disentangle that either.
So let me tell you the story of Terry Williams. I think I mentioned him earlier. The essay is called "When a Kid Kills His Longtime Abuser, Who's the Victim?" Terry Williams came within 2 hours of execution. He was an 18-year-old kid who had killed his abuser. The prosecutor kept evidence that the victim was an abuser from the defense attorney. She eliminated all of the evidence that he was in fact an abuser, and she made him sound like an innocent victim. The defense lawyer met his client, 18-year-old Terry Williams, one day before his capital trial. Terry came within 2 hours of execution, and the prosecutor, who at the time was advocating to lengthen the time for victims of sexual abuse to come forward, trying to make it easier for sexual abuse victims to come forward, at the same time was trying to execute Terry Williams because he hadn't come forward as an 18-year-old kid who had just met his lawyer one day before his capital trial. So the hypocrisy of that scenario is astounding. And the lack of sense, this is the pre-Krasner Philadelphia District Attorney's Office, the lack of sensitivity was astounding. And Terry Williams, had a judge not ordered the prosecutor's file to be opened, and had the defense attorneys not seen the whitewashing of the discovery that was provided, he would be a dead man today. Killed his abuser.
So I guess the last question I'll ask you for now is, what do we do about, the clear-cut case, maybe a Ted Bundy, right? Bad guy, clearly intelligent, simply didn't care. Or, kind of the poster children for the death penalty case, because clearly a lot of these cases, a lot of people will say, well, okay, I support the death penalty, but yeah, maybe not in this case. How do you respond to that?
I love that question. But you may not I love that question. Let me just say that. So you mentioned Ted Bundy, and I get this a lot. What very few people know is that the prosecutor did not think that it was necessary to execute Ted Bundy. Prosecutor offered Ted Bundy a life sentence. Bundy was, and you said there's, I don't know, you didn't really mean it. You said, let's assume there was nothing wrong with him. There was a lot wrong with Ted Bundy. He was a profoundly traumatized guy. A lot of things wrong with him. He was unable to navigate the system, to understand that he should have taken that life sentence. So the interesting thing about the Bundy situation is that the prosecutor didn't think it was necessary to execute him. We have these maximum security prisons that make the death penalty completely not necessary, because we can protect the society. But let's talk about some other awful cases. We just experienced one in Florida, a couple of months ago. The Parkland case, that's a perfect example of how people that are not, they're not necessarily paying close attention. They just know how awful the case was. And of course, it was a horrifying case. But that jury saw fit not to give Nicholas Cruz the death penalty. They saw the profound and compelling mitigation story that was provided there. And so they looked at that case and they decided, we can protect the community. We can punish Nicholas Cruz, but we don't need the death penalty. So what I say to people is, we've got these maximum security prisons. The death penalty is more costly. It's going to take years and years of litigation before it's achieved, and we can keep our communities safe. So, what I say, I'm happy to give you my moral metaphor about the death penalty. I'll throw that in just at the end. It's from The Lion King. And I'm talking about the animated Disney version of The Lion King, where Mufasa is this great citizen. He's the leader of his community, and he's intentionally murdered by Scar, his brother, and then Scar compounds the murder, the aggravation of the murder, by basically blaming his son, it's Mufasa, Scar, and Simba. He frames Simba for the crime. So Simba grows up thinking he's responsible for his father's death, and Scar does it for the worst possible reasons, which is he wants to take over the pride of the lions. And Simba grows up and he confronts Scar. And Scar, they have kind of a lion-like trial, and they roll around in the dust, and Simba ends up on top of him. And Scar says, "What are you going to do now, Simba? Are you going to kill me?" And I years and years ago, I stopped the tape and asked my 6-year-old daughter what she thought Simba should do. She said, "It's not nice to kill people, even if they're mean." And try to imagine what Simba says are the classic words from my point of view, which is, "I'm not like you, Scar. I'm not going to act like a heinous criminal, right? I'm not going to do to you what you did to my father. I'm not going to act in a horrible way." And instead he basically bars Scar from the community. That's kind of a life sentence, for lions. But try to imagine for 1 second if Disney had rewritten the movie and had Simba saying, "Yes, Scar, I'm going to tie you to a gurney. I'm going to load up this syringe with poison, and I'm going to inject it into you until you're dead." Every 6-year-old in the theater would go screaming out of the theater, and the parents would be suing Disney for trauma, right? Because we all know that that's no way for a good person to act. Simba should not be injecting Scar with poison. And yet we've got no trouble doing that as adults. And so somewhere between the age of 6 and the age of adulthood, we lose the sense that it's not nice to kill people, even if they're mean. Murder's it's just wrong any way you cut it. So that's my moral pitch against it. That's my moral guidance against the death penalty.
Perfect way to end. So I want to thank you for coming on. We've been talking with Marc Bookman. He's the author of A Descending Spiral, Exposing the Death Penalty in 12 Essays. I highly recommend the book. Thanks for joining us this week.
David, it was my pleasure. Thanks for having me.
This has been Everyday Injustice. I'm your host, David Greenwald. Join us again next time for more tales from the injustice system.
Thank you to George Powell and Norman Mousequake Barrett for the use of our opening, Everyday Injustice. You can see more of George's music at www.justiceforgeorgepowell.com. That's Justice for George Powell, all one word, .com.